Article 109 Agreement Canon 2144 An agreement, also known as a contract, is any mutual oath, vow, deed, covenant, will or pact between two or more persons through valid document form to do or refrain from doing certain acts or obligations. Canon 2145 By definition, an agreement or contract is only valid when it is registered into a great register of a Eucadian society. Canon 2146 Agreements may be defined by two main types as defined by the way the primary relationship between the parties is formed in contract: 1. Unilateral and 2. Bilateral. A bilateral agreement is an agreement in which each of the parties to the contract makes a promise or promises to the other party. A unilateral agreement is where only one party to the contract makes a promise. Canon 2147 For any agreement to be valid in it must comply to the following essential elements: I. Adherence to the requirements of primary form of these canons, including required terms and conditions of such form, and 2. Evidence of an express or implied agreement, consent to a contract of valid primary form, and 3. Consideration given by all the parties which conforms to the limits defined by the primary form of the contract chosen to enter, and 4. That both parties have the capacity to understand the terms of the contract they are entering into, and the consequences of the promises they make, and v. That both parties are properly authorized to enter into such a primary form of contract, and vi. That the subject matter and consideration of the contract is lawful and consistent with these canons, and 7. That the contract provides the correct right for remedy and limits as determined by the primary form, and 8. Separate to the consideration, both parties must have some obligation to fulfill to the other. Canon 2148 In the interpretation of an agreement against the rules of general validity, the following general guidelines are to be followed: I. The common intention of the parties rather than adherence to the literal meaning of the words shall be sought in interpreting a contract, and 2. In interpreting a contract, the prime form of the contract and the common interpretations given to it by statute, previous court decision and use are to be taken into account, and 3. Each clause of a contract is interpreted in light of the others so that each is given the meaning derived from the contract as a whole, and 4. A clause is given a meaning that gives it some effect rather than one that gives it no effect, and v. Words susceptible of two meanings shall be given the meaning that best conforms to the subject matter of the contract, and vi. A clause intended to eliminate doubt as to the application of the contract to a specific situation does not restrict the scope of a contract otherwise expressed in general terms, and 7. The clauses of a contract cover only what it appears that the parties intended to include, however general the terms used, and 8. In case of doubt, a contract is interpreted in favor of the person who contracted the obligation and against the person who stipulated it. In all cases, it is interpreted in favor of the adhering party or the consumer. Canon 2149 While the rules of general validity must be met for an agreement to be valid, the rule of consent is such that it requires further detail. The following elements: if one or more are identified, void consent, I. That the person did not give consent, but the other party committed a fraud by indicating consent was given through forgery, or 2. That the person making consent was not authorized to make such consent, or 3. That the person making consent was not competent at the time to make such a consent, or 4. That the person making consent did so under clear pressure and or duress, or v. That the person making consent did so under threat of harm or injury to other person or property. Canon 2150 An agreement creates obligations and, in certain cases, modifies or extinguishes them. Canon 2151 Valid agreements, contracts, must be kept. Canon 2152 An agreement between inferior persons cannot abrogate, modify, supersede or replace an agreement between superior persons. Therefore, No agreement claimed by a Roman society or its agents can claim to be superior to an agreement issued in accordance with these canons. Canon 2153. As any claimed agreement by a Roman society cannot abrogate, modify, supersede or replace an agreement between superior persons, any agreement entered into through a Roman society shall have no force of law, binding nor validity when challenged in accordance with these canons. Canon 2154. A breach of contract is a legal cause of action in which a binding agreement or bargained exchange is not honored by one or more of the parties to the contract by non-performance or interference with the other party's performance. Canon 2155. There are primarily three classes of breaches of contracts: minor, material and fundamental. A minor breach of contract, also known as a partial breach, occurs when the non-breaching party is only entitled to collect the actual amount of damages and not for any order for performance of obligations. And, 2. A material breach of contract is any failure to perform that permits the other party of the contract to either compel performance or collect damages because of the breach. And, 3. A fundamental breach of contract is a breach so fundamental that it permits the aggrieved party to terminate performance of the contract, in addition to entitling that party to sue for damages. Canon 2156. Proof of fraud in construction, disclosure or performance of a contract constitutes a fundamental breach. Canon 2157. A contract founded on fraud is null and void. Article 110. Offer. Canon 2158. An offer is an invitation to consent and enter into a binding contract communicated to another party which contains terms sufficiently definite to create an enforceable contract if the other party accepts the invitation. Canon 2159. An offer must be first made before an agreement can lawfully be accepted. Canon 2160. Mere recommendation of an article does not bind the vendor of it. Canon 2161. As the original and true definition of judgment is to bind together the mind and person, all judgments of the court are an offer requiring consent, usually through the interpretation of absence of objection. Canon 2162. In the presence of a vocalized objection, non-consent or counter-offer, a judgment shall have no legal or lawful effect, regardless of what a judge or magistrate may claim. Upon appeal, such a judgment must be rendered invalid and reparations made. Canon 2163. In the presence of a vocalized objection, non-consent or counter-offer to a judgment, by law an alternative judgment must be offered by the judge or magistrate for an agreement and therefore the judgment to be valid. Article 111. Option. Canon 2164. An option is an agreement granting the right to buy, sell or convey property at a certain price by a certain time. The person or grantor who grants the option is called the optioner and the person who receives the benefit of the option is called optionee. Canon 2165. Options generally exist in one of two primary forms: a call option and a put option. Canon 2166. A call option is when the beneficiary, option E, is granted the right to require the grantor, optioner, to sell or convey the property to them at an agreed price within an agreed time limit. Canon 2167. A put option is when the beneficiary, option E, is granted the right to require the grantor, optioner, to buy or receive the property to them at an agreed price within an agreed time limit. Article 112. Consideration. Canon 2168. A consideration is the offer of something possessing value given as incentive or recompense for a previous promise which then causes the promise to become binding as a contract if accepted. Canon 2169. A consideration is valid for use in securing a new contract as well as remedy for repairing a breach to an existing agreement, such as a lease. Canon 2170. Where a tenant of a lease of reasonable time is unable to meet the full payment of rent, consideration is essential in protecting the right to claim their right of redemption, also known under mortgage laws as equity of redemption. After consideration and partial payment of rent, represented by the interest on the loan of mortgage. It is both unlawful and gross fraud against all forms of contract law to permit a foreclosure hearing to continue. Canon 2171. It is the responsibility of the vendor, not the buyer, to first provide full disclosure and act in good faith and honesty. Article 113. Necessity. Canon 2172. Necessity is the unavoidable requirement of a party to consent, act or perform in a manner that they would not otherwise do if not for the presence of some clear need, threat, coercion, danger or risk. Hence, any oath, vow, sign or seal given under necessity has no legal validity or value. Canon 2173. Compliance to an order or demand under necessity can never be lawfully claimed as consent, providing the party makes clear such compliance is under duress, either vocally as well as including such words with any sign or seal. Canon 2174. Contrary to any statutes, rules or orders that are in conflict with this canon, when a man or woman professes that they complied to some order, demand or act out of necessity and under duress, then any oath, vow, sign or seal given is automatically null and void within 7 years of such an act or acts of necessity. Canon 2175. Excluding alleged serious offences involving violence, sexual abuse or dishonesty, no man or woman may be accused of any offence when professing they undertake or have complied with an act under duress as a necessity. Canon 2176. When a man or woman pronounces in advance that they shall comply to some order, demand, bond or promise out of necessity under duress, then the subsequent execution of such an order, demand, bond or promise constitutes a clear, proven and serious act of fraud on behalf of the trustee, administrator or executor issuing such an instrument. Article 114. Consent. Canon 2177. Consent is the agreement of one party to a claim presented by another. In the absence of consent of all parties, justice does not exist. Canon 2178. No injury can be complained by a consenting party. Canon 2179. Silence by the court, not the parties of a case, is consent. Canon 2180. In the absence of fraud and deception, consent removes or obviates a mistake. However, fraud negates consent. Canon 2181. Any witness before the courts who witnesses a claim before them and does not deny, therefore admits. However, without witnessing such a claim, even in silence, nothing can be rightfully concluded. Canon 2182. In the absence of any threat or fear, silence to an accusation duly disclosed may be inferred as consent. Canon 2183. The agreement of the parties makes the law of the contract. Canon 2184. Unless deceit can be proven, a person who consents cannot reject the obligation arising. Canon 2185. When any matter is brought before a court having established proper jurisdiction and when consent has been given by both parties for the matter to be heard by a judge and or jury, a proper contract then exists between all parties to seek resolution by a judgment. Canon 2186. When duress is evident upon one party in bringing a matter before the court, whether it be by the presence of armed court officials, or the use of threat and intimidation, then no valid contract exists and no judgment on the matter can be considered to have been properly rendered, as due process of law has not been followed. Canon 2187. Natural birth of the flesh is proof of lawful conveyance from a divine trust to a true trust as a result of willing consent by the divine person to be born in accordance with these canons. Therefore, the existence of the body of a living flesh Homo sapien is proof of their divine, ecclesiastical, consent to obey these canons. Article 115. Obligations. Canon 2188. An obligation is something, as a formal contract, a promise, or the demands of conscience or custom, that obligates one to a course of action through some agreement, instrument, product or transaction. Canon 2189. Obligations agreed in good faith, free from fraud and duress, are to be met. Canon 2190. When fraud by one party is proven to exist, the other parties are released from all obligation. Canon 2191. Failure to perform an obligation without legal excuse gives the other party the right to seek legal remedy. Canon 2192. No one may be obligated to perform an impossibility. Canon 2193. No one may be obligated to perform a fraud or other offense. Canon 2194. No one may be obligated to perform an act against their conscience or moral faith. Canon 2195. The failure to perform one or more obligations of a formal contract may be grounds for the extinction of a contract, or punitive acts as stipulated within the contract. Article 116. Performance. Canon 2196. Performance is an action itself or its completion as stipulated and required under some form of agreement. Hence, the performance of a contract is executing the actions defined by the agreement. Canon 2197. By the very nature of an agreement, all agreements define at least one action to be performed by all parties, namely to follow the terms of the agreement. Thus, performance of an agreement is equivalent with honoring an agreement. Canon 2198. As performance is equivalent to honoring the terms of an agreement, non-performance is equivalent to dishonoring the terms of an agreement. Article 117. Surety. Canon 2199. Surety is when a person undertakes some specific responsibility on behalf of another who remains primarily liable. Hence, surety is one who makes themselves liable for the default or miscarriage of another, or for the performance of some action on their part, such as the payment of debt, appearance at trial, or underwriting of bond. Canon 2200. Excluding a mistake of fact, or some deliberate deception or fraud. When a man or woman acts or engages with another through a fictional person, they automatically assume surety for that person even if they have no rights concerning that person. Canon 2201. No man or woman may be forced to act as surety to a particular person, especially when the trustee or owner of that person may have acted deceptively and dishonorably in failing full disclosure of attached rights and obligations. Canon 2202. When any official person, trustee or owner acts in a deliberately deceptive and dishonorable manner in order to compel a man or woman to act as surety for a person, all debts and liabilities for that person automatically are assumed by the official, including consent for any punitive action, including the charging of criminal offenses and expulsion from office. Canon 2203. When any official person, trustee or owner acts in a deliberately deceptive and dishonorable manner in order to compel a man or woman to act as surety for a person, any ordinances, orders or punishments are automatically unlawful, having no validity or effect. An official charged with unlawful orders or punishments may not claim any form of immunity. Canon 2204. Excluding deliberate fraud or deception, a man or woman cannot extinguish their surety for a person until any debts and liabilities are paid, unless the person is an inferior person. In such a case, the man and woman must give proper notice of non-consent as surety, and for all debts and liabilities to be returned to the trustee to be sent to the owner of the inferior person for payment. Canon 2205. No inferior juridic person has the right to deny the recording and use of a higher form of person by any man or woman as surety in replacement for a lesser and inferior person. Article 118. Seal. Canon 2206. Seal is the act of affixing a symbol to a valid document to attest its valid production, recording and registration, or to bind its contents as a solemn promise or execute its contents by authority. Canon 2207. The word seal originates from the 1st millennium BCE Gaelic word seal, meaning a formal binding promise usually associated with the use of property called usaid and surety called tithe. Hence, in the formation of the first sophisticated property laws of civilization, possession of property in Gaelic became known as seale, bonded property, and a promise. Surety of property was called from the beginning an éiread, property promise. Canon 2208. A seal may be impressed by some device, printed or attached to a document as evidence of authenticity, confirmation or attestation. A seal also denotes a valid binding whereby a document is enjoined to others through the seal to become one, in the case of valid statutes and ordinances. Canon 2209. Once impressed, printed or affixed, the power and authority bestowed by a valid seal elevates or raises the status of the document according to the office of the seal and its associated registration. Therefore, the use of ornaments, wax, wafer, color or other devices to physically raise, attach or alter the physical material of the document is immaterial to the legitimate effect of a seal. Canon 2210. There are only six valid types of seal: absolute, great, official, ordinary, inferior and private. An absolute seal is the most powerful and highest authority of seal and signature when a man or woman uses their thumbprint in red ink to give life and personality to a document in their capacity as executor of their own true trust and general executor of the estate of their legal person. And, 2. A great seal is the second highest possible seal and is the official seal of any juridic society person or juridic public person. Hence a great seal is used for the authentication of documents of the highest importance issued in the name of a universal true trust, global true trust or civil true trust. And, 3. An official seal is the third highest possible seal issued by an official person in the capacity of their office on behalf of a universal true trust, global true trust or civil true trust. And, 4. An ordinary seal is the fourth highest possible seal issued on behalf of a juridic private person, juridic union person or juridic domestic person in association with a superior trust. And, v. An inferior seal is the fifth highest possible seal issued on behalf of a non-Eucadian legal person. And, vi. A private seal, also known as an inferior administrative seal, is the lowest form of seal and is an administrative stamp issued under private law between parties for the cross-certification of documents by regulation and central registration of all authorized signatories. Canon 2211. An apost is an example of a private seal whereby private Roman nations who are signatories to a private Hague Convention from 1961 have agreed to recognize and certify each the documents of each other for legal purposes by ensuring the registration of officials who are authorized to seal documents under private international law. Canon 2212. All documents associated with the administration of property as well as the conveyance of property such as deeds must be properly sealed. Canon 2213. The denial of any inferior Roman person of the validity of a perfected document sealed by a superior seal is tacit and public notice that all Roman instruments are hereby null and void, having no validity in law. Article 119. Sign. Canon 2214. A sign, or signature, is the act of affixing a name, word, letter or other identifying mark of a legal person to a valid document to attest its authenticity as witness or execute its contents by agreement or to give it effect as surety for one's own act. The word sign and signature comes from the Latin word signo, signatum, meaning to mark, stamp, print, to seal a document, to coin or mint money, to impress, designate or note. Canon 2215. A signature may be written by hand, printed, stamped, typewritten, engraved, photographed, or cut from one instrument and attached to another, and a signature lithographed on an instrument by a party is sufficient for the purpose of signing it, it being immaterial with what kind of instrument a signature is made providing it is done through legitimate use. Canon 2216. Legitimate use of a signature is when the man or woman affixing the signature to the valid document is authorized in some verifiable manner to affix such a name, word, letter or other identifying mark of a particular legal person. The affixing of a signature by a man or woman who does not have proper authority to do so for a particular legal person renders such a signature null and void from the beginning. Canon 2217. There are primarily two forms of signature by convention, being the executor or the trustee/beneficiary. The signature by executor is by custom and convention the first name only of the legal person to whom they are executor and the letter R, including the period, for Latin regnatum, meaning to be king, rule, reign, to be supreme lord of an estate, and, 2, the signature by trustee, beneficiary is by custom and convention either an X, a blood splotch, or the full name, first name and family name, in stylized script. Canon 2218. By custom and function. When a signature is affixed to a document it is either to bear witness to its authenticity, grant certain rights by execution or submit as surety to the contents of the document. I. An executor never signs their name in the manner of a trustee, beneficiary unless they are acting in such capacity, and only ever signs as first name and the letter R. When in the context of a grant, deed and conveyance. In all other cases, an executor never signs a document, and, 2, a trustee, beneficiary signs their full name in the manner of a trustee, beneficiary as a witness to the authenticity of a document or to accept full liability and as surety to perform its contents. Canon 2219. When a man or woman is compelled by force to sign a document, such a signature shall have no legal effect. To ensure this is made clear, a man or woman may lawfully choose one of two mechanisms to physically invalidate their signature. I. By placing the letters VC anywhere within the signature. The man or woman signifies by custom the principle of vicoctus or compelled by force to sign, which immediately invalidates the whole document. Or, 2, if a prevented from making clear a signature is made by force, a man or woman may use 3 ellipseg anywhere as part of their signature to prove that they sought to sign VC but were otherwise prevented. Canon 2220. Whether a man or woman has signed a document or not, if it can be proven that such signature was elicited under false pretense, under duress or some other fraud, then such a signature is null and void. Canon 2221. All documents associated with the administration of property as well as the conveyance of property such as deeds must be properly signed and sealed. Article 120. Witness. Canon 2222. Witness is the attestation of a fact, action, testimony or evidence. The term witness also applies to the person who performs the action of being a witness. Canon 2223. In any mutually accepted agreement, a minimum of 2 witnesses are required, being 1 for each party. Canon 2224. When a mutual agreement is not yet perfected, a minimum of 2 witnesses for one party may be sought to validate the facts of their claim, or a valid notary. Canon 2225. The witnessing of documents of non-inferior persons shall be by real seal, great seal, ordinary seal or official seal as is appropriate. The use of signature shall not be permitted. Canon 2226. When invoking status as a divine immortal spirit, all angels, saints, spirits and the divine creator are called and accept the role as witness to the attestation of fact, action, testimony or evidence in accordance with these canons. Canon 2227. The most powerful and valid attestation of a fact, action, testimony or evidence is when one or more instruments issued under the invocation of status as a divine immortal spirit are witnessed by at least 2 other men or women, and such instruments are recorded by some public means as proof of service. Article 121. Remedy. Canon 2228. Remedy is a fictional concept in reality whereby an injured party receives a form of cure, repair, correction, compensation and justice against an injury in accordance with these canons and any valid statutes promulgated by valid juridic persons. Canon 2229. The damage, loss, violation or hurt to a physical object or concept under natural law itself does not automatically warrant remedy, as remedy requires the pre-existence of a fictional framework of reality, laws prohibiting certain actions, an injured form, an accused form and a lawful ordinance against the accused. Canon 2230. Any decree, prescript, rescript or ordinance that is not in accordance with these canons is not a valid statute, nor law but a false edict and therefore null and void from the beginning. Article 122. Restitution. Canon 2231. Restitution is the restoration of certain rights to a party as remedy to an injury. Canon 2232. As restitution is the restoration of certain rights to a party, the process of restitution may involve replacement, rebuilding, return, renewal, reverse or reform or a combination of some or all the qualities. Canon 2233. Restitution is not the same as compensation in that restitution seeks to restore certain rights, While rights or benefits granted under compensation may be equivalent in value but completely different to what was originally lost. Canon 2234. When a party successfully claims the loss of one or more rights to which they are entitled, a competent authority may choose to either order restitution or compensation or both in some way. Canon 2235. Restitution is superior remedy where the lost rights may be recovered or restored. Article 123. Compensation. Canon 2236. Compensation is the provision of certain rights and benefits of equivalent value to a party to make up for the loss of other rights through injury that cannot otherwise be recovered. Canon 2237. When certain rights are injured, they may be impossible to recover. An example is when a man or woman may suffer a serious injury or death on account of the negligent actions of another. In such a case, a competent authority may choose compensation as part of the remedy provided to the injured party, or next of kin. Canon 2238. Compensation is not the same as restitution in that rights or benefits granted under compensation may be equivalent in value but completely different to what was originally lost, whereas restitution seeks to restore lost rights. Canon 2239. Compensation is superior remedy where the lost rights cannot be recovered or restored. Article 124. Assignment. Canon 2240. Assignment is when a party to an agreement transfers some or all of their rights to another person not originally party to the agreement. The party who seeks to assign their rights to another is typically called the assignor, and the one who accepts these rights is called the assignee. Canon 2241. Unless otherwise prohibited by the original terms of the agreement or some higher deed of trust in effect, all parties possessing rights are considered to have the right to assign some or all of their rights to another party. Canon 2242. Delegation is equivalent to a form of assignment whereby a party to an agreement substitutes another as their representative in holding certain rights. Canon 2243. An assignor can never lawfully assign their original obligations to perform under an agreement. Only rights. While the rights of an assignor may be legally transferred to an assignee, the assignor always retains liability. Canon 2244. Assignment is not the same as novation. Novation is when an obligations or party is replaced by new obligations or party under a new contract based on an old agreement, whereas assignment does not create a new contract, merely delegates the rights of one party to another. Canon 2245. An assignor that falsely presents an assignment as a novation is guilty of fraud and therefore consents to accepting the full liability of all parties to the agreement, including any restitution or compensation. Canon 2246. An assignor that refuses to perform their obligations is in breach of contract with the other party possessing the right to restitution or compensation, regardless of how many times the agreement has been reassigned. Article 125. Novation. Canon 2247. Novation is when all parties to an original agreement consent to alterations reflected in a new agreement. Hence to novate is to create a new agreement based upon a previous agreement. Canon 2248. A novation or novated agreement is a new contract requiring the consideration and consent of all parties. Any lack of disclosure, proper offer and consent may constitute fraud by one or more parties, negating the validity of the contract. Canon 2249. Novation is not equivalent to assignment. Assignment does not create a new contract, merely delegates the rights of one party to another, whereas novation is when an obligation or party are replaced by new obligations or party under a new contract based on an old agreement. Canon 2250. Consent and agreement by novation can never be assumed or implied, but must be explicitly demonstrated as with all valid agreements. The agreement on the previous agreement has no material significance to the agreement of the new, novate, agreement other than the fact the agreement succeeds the other. Canon 2251. While a novated agreement may introduce a new party such as an obligor, it is the original obligor that must also consent and be named as a transferring party as part of the assignment built into the novation. Canon 2252. Upon a valid novated agreement coming into effect, The previous agreement is terminated other than to the extent that rights surviving termination are agreed to continue by mutual consent.